Hey, AP Gov, I hope you're doing well, staying safe, social distancing, etc. Um, this case happened, I think it was last night, and then as I looked at the news this morning, it was everywhere. And so I thought that I would share it once I've read the opinion because it's very interesting and not necessarily what the news is perhaps reporting. So, a couple of things for context before we get into this whole thing. First of all, the headlines, very interesting stuff. And they're not wrong. It's just, I don't feel like it's necessarily the full story. So, you see here, holds its election in the middle of a pandemic, amid pandemic, blah, blah, blah. This is true. This is true. Um, Now, when I first saw the story, I was like, wow, this is stupid. Like, how can they not postpone it? This is absolutely just ridiculous. But while I still do hold that opinion, I after reading the opinion, the official opinion, I understand better as to why the decision was made. And then reading the dissenting opinion, it also makes a lot of sense. You have to keep in mind that when you read majority and dissenting opinions, if there is a dissenting opinion, that all of these people on the Supreme Court are very smart. And so you have to really like look at both sides of the issue because if you just read the dissent, it may make perfect sense and you may totally agree with that. But then you read the majority and you're like, oh, they also have good points. So a lot of times these issues are not as cut and dry as Brown v. Board. That's cut and dry. That was a unanimous decision. You can't argue against it. But most opinions or most cases end up with a majority opinion and a dissenting opinion because you have smart people who are discussing law and it becomes very complicated. So, another thing. So, here is a picture of the current Supreme Court justices. One of the things that is normally tested on the AP Gov exam and won't be this year because it's bizarre, but normally there's a question about how the Supreme Court is the branch that is most insulated from public opinion. And as I've said in class, like a lot of times you don't see these people interviewed. You don't see them, talking about their opinions and stuff. They do, but not nearly as much as politicians and stuff like that. They're not normally in front of a camera. In fact, in the Supreme Court itself, like in the room, there's no cameras. So, like that's legit. Like you don't see them talk. But the reason why is because they give out and they write their opinions at the end. It explains exactly what they were thinking, exactly why they decided what they did. And so there's not really a need to do interviews. Like they just told you exactly why they did it. What questions are you going to ask them? Why did you do this? Why did you? Well, I put it in my essay. Didn't you read it? So they are insulated from public opinion because here's the thing. Again, if we look at these headlines, and if they were up for reelection, you wouldn't have voted for them, right? You'd be like, this is so stupid. I'm not going to vote for you. And so, because of that, because of the fact that they're insulated from public opinion, it allows them to hold truth to the law and the legalities of things in the Constitution, as opposed to what people find popular and what people are offended by. So, that's a very important thing. Another important thing to keep in mind for context is you have to remember that Supreme Court cases are very technical and are about a specific thing and not necessarily the story. What I mean by that, if we rewind to one of the first cases that we learned about, US v. Lopez. In this case, and this is a website called Oh Yay. Oh Yay, not Oh Yes, was what I was saying. Oh Yay. So again, there was this kid, this happened in the 90s. This kid had a gun and he brought it to school. And then, and he was charged in Texas. And then they dismissed those charges because federal charges were brought against him because he violated the Gun Free School Zone Act of 1990. And It's not a question about did he have the gun? He did. The question is this act itself constitutional? Again, it's not about did he have the gun? It's about whether this is constitutional, because if it is not, then it doesn't matter whether he had the gun or not, because the rule itself is unconstitutional. So that was one of the first cases that I brought up, because you need to understand that it is really about this minute detail of this, not about whether he had the gun or not. It's about whether or not the rule itself is fine. And also it has to do with the Commerce Clause and how this doesn't apply because the Commerce Clause does not give them this power. So it's a twofold thing. But I feel like the more important part of this is that most people think that the cases in courts are about the story. But when it gets to the Supreme Court, it's not about whether he's guilty or not. It's about the constitutionality of the issue. Okay. With all that being said, let's get to the opinion. So all you have to do is you just type in like Supreme Court opinions, and then you'll get like this page. So it says opinions of the court 2019. I think that's just because they started this like season, so to speak, in 2019. You see here April, which is, this month, 4/6, so that was yesterday. It tells you the docket number, and then it gives you the title of the case. You see Republican National Committee versus the Democratic National Committee. So notice here, National Committee. Please remember, with the political parties, there are national versions. So there's the Republican National Committee, there's the Republican Texas Committee, there's the Republican Party of Harris County, like all that stuff. There's lots of different versions, but nonetheless, if you click on that, you get a PDF. This PDF is only 10 pages long. I love to read opinions because I feel like they're written in a way that a fairly educated person can understand. You don't need a college degree to understand these. It breaks it up very specifically as to what the issue is, why we decided it this way, blah, blah, blah. Okay. Also, you see here, again, the docket number. You see the title of the case. You see the majority opinion. If we scroll down, we see by Ruth Bader Ginsburg, the dissenting opinion. So the majority opinion is what most of the people on the court agreed, and the dissenting opinion is why the justice disagrees with the majority opinion. If everyone agreed, let's say that there's like 3 people who dissent. Let's say that they all agree on the reasoning why, they would just write one dissenting opinion. If you have 3 different opinions, like if they all disagree, but they disagree for different reasons, you could have 3 different essays. So here we see Justice Ginsburg, Breyer, I don't know, Sotomayor, and Kagan all came together to discuss why they disagree, why they dissent. Okay. That means that everybody else is part of the majority opinion. Okay. So I want to just get into this. And as I'm going to read it, I apologize. But as I read it, I'm going to discuss important things. Okay. Also, what you'll notice is like Latin and stuff. And, I'm not a lawyer. Like I took Latin for 1 year in high school. So I am not well versed in it. But, we can Google it or we could just move on. I think it means like per the court or something. Okay. I did Google it, but I can't remember what it was. Okay. So the application for stay presented to Justice Kavanaugh and by him referred to the court is granted. And it says application for stay. Okay. So like to reaffirm, I guess. The district court's order granting a preliminary injunction is stayed to the extent it requires the state to count absentee ballots postmarked after April 7, 2020, which is today. And this was yesterday. Okay, that will come into play. Wisconsin has decided to proceed with the elections scheduled for Tuesday, April 7, again today. The wisdom of that decision is not the question before the court. That's important. The question before the court is a narrow technical question about the absentee ballot process. In this court, all agree that the deadline for the municipal clerks, municipal meaning city, clerks, to receive absentee ballots has been extended from Tuesday, April 7 to Monday, April 13. That extension, which is not challenged in this court, has afforded Wisconsin voters several extra days in which to mail their absentee ballots. The sole question before the court is whether absentee ballots now must be mailed and postmarked by Election Day, Tuesday, April 7, as state law would necessarily require, or instead may be mailed and postmarked after Election Day, so long as they are received by Monday, April 13th. Importantly, in their preliminary injunction motions, the plaintiffs, meaning the people who are asking for this, did not ask that the district court allow ballots mailed and postmarked after Election Day, April 7, to be counted. That is a critical point in this case. Nonetheless, 5 days before the scheduled election, the district court unilaterally ordered that absentee ballots mailed and postmarked after Election Day, April 7, still be counted so long as they are received by April 13th. Extending the date by which ballots may be cast by voters, not just received by the municipal clerks, but cast by voters, for an additional 6 days after the scheduled election day fundamentally alters the nature of the election. Pause. So, if you look at these headlines and if you look at the articles, it makes it sound like the Supreme Court was deciding whether or not Wisconsin should have the election. That is not at all what the question was. The question was, okay, I feel like I need to explain this. Okay. An absentee ballot means someone who is absent, right? Someone who is not going to the polling location. So a normal voter will go to the polling location. They will check in. They will get that little piece of paper with the number on it. And then they'll go to a booth, basically, and they'll put in their vote. Okay. However, let's say you are a Texan, you are 18, you go to school in California. You cannot go to the ballot. Well, you cannot go to the polling location. You can, but you do want to, vote. So what you need to do is you need to ask for an absentee ballot, and then you can vote through the mail. Okay, that's what an absentee ballot is basically a mailed vote. So basically what I thought when I saw the news was that they were saying whether or not Wisconsin should postpone the election, which I would agree with. But that's not the question. The question is whether absentee ballots now must be mailed and postmarked by Election Day, meaning they need to put it in the mailbox today and have it stamped. Postmarked means like not like a postage stamp, not like the little stamp with a flag on it. Postmarked means like an ink stamp on the envelope that says like Houston, Texas, and it has the date. Gosh. Okay. Let me log out of here, please. Sign out. There we go. So, my apologies. So, that's the question. The question is, should they have to put their ballot in the mailbox by today and have it postmarked today? Or should they be able to put it in the mailbox over the course of this April 13th for the next week? That's the question. We'll come back to that. Okay. Nonetheless, 5 days before the scheduled election, the district court unilaterally ordered that absentee ballots mailed and postmarked after Election Day, April 7, still be counted so long as they are received by April 13th. Meaning that if it has April 7th stamped on it or earlier, they will be counted even if they are received after April 7th. Extending the date by which the ballots may be cast by voters, not just received by the municipal clerks, but cast by voters, for an additional 6 days after the scheduled election day fundamentally alters the nature of the election. And again, the plaintiffs themselves did not even ask for that relief in their preliminary injunction motions. Our point is not that the argument is necessarily forfeited, but it is that the plaintiffs themselves did not see the need to ask for such relief. By changing the election rules so close to the election date, and by affording relief that the plaintiffs themselves did not ask for in their preliminary injunction motions, the district court contravened this court's precedents and erred by ordering such relief. Okay, let's talk about that. By changing the election rules so close to the election date, and by affording relief that the plaintiffs themselves did not ask for in their preliminary injunction motions. Okay, so this is important. Changing the election rules so close to the election date, and the court giving the plaintiffs, the people asking for this, something that they did not even ask for, is a problem. And it says it's going against the precedents, like the legal precedents of what has happened in the past. And it says that they've made a mistake. They've erred, like an error, right? This court has repeatedly emphasized that the lower federal courts should ordinarily not alter the election rules on the eve of an election. Then it tells you the legal precedent that they focused on. Again, legal precedent meaning the cases from the past that help inform their current cases. So again, we've talked about that in class of how, you have a house that's broken into and the same crime happens years apart, but with the same basic situations happening, and one guy gets 5 years and one guy gets 20 for the same crime. That goes against the legal precedent, right? You have to make an informed decision based on past rulings. So I looked up Purcell versus Gonzalez. So again, Oye, Maricopa County, Arizona. This is interesting. In 2002, Arizona passed Proposition 200, which required a voter ID for voter registration. The Election Assistance Commission notified Arizona's Secretary of State that Proposition 200 conflicted with the National Voter Registration Act regarding the need for photo ID as proof of citizenship for mailed voter registration forms. Shortly thereafter, the plaintiffs, Arizona residents, Indian tribes, and community organizations, so again, plaintiffs meaning the people who bring this case to the court, filed a restraining order to prevent the state of Arizona from enforcing the new rules for voter registration. The petition for a restraining order was denied by the district court. The plaintiffs appealed to the U.S. Court of Appeals for the Ninth Circuit and argued that it should grant an emergency injunction, meaning an injunction is like an emergency brake, like blocking it. Okay, blocking it. Based on the fact that the elections were about to begin. The appellate court granted the injunction to stop the enforcement of Proposition 200. This is the important thing. Based on the fact that the elections were about to begin. And I think what's interesting about this is that it has to do with voter ID. And voter ID is like something that Republicans typically go for and Democrats typically don't, because they feel like it disenfranchises voters. So I think it's interesting that the people who voted or like were on this side of the decision mostly were like Republicans, and most of the dissenters were Democrats. But the Republicans used this to help support their decision. But here's the thing, too. Supreme Court justices typically favor Democratic policies or Republican policies, but they should not be Republican or Democrat. They should focus on the Constitution and legalities. But anyway, okay. The unusual nature of the district court's order allowing ballots to be mailed. Oh boy, let's start again. The unusual nature of the district court's order allowing ballots to be mailed and postmarked after Election Day is perhaps best demonstrated by the fact that the district court had to issue a subsequent order enjoining the public release of any election results for 6 days after Election Day. Meaning this. In this opinion, they're saying, this is weird, and just look at the fact that the district court had to tell people that you cannot release election data for 6 days after the election. That's bizarre. As we talked about before, like normally, you can go home and turn on the local news at like 6 o'clock, 7 o'clock, and they'll start showing you all their election results. So for them to order that you're not allowed to share that data for 6 days is different, is unusual, as he says here. In doing so, the district court, in essence, enjoined non-parties into this lawsuit. I think what they mean is like news people and like just people talking about election results, I think. It is highly questionable, moreover, that this attempt to suppress disclosure of the election results for 6 days after the election would work. And if any information were released during this time, that would gravely affect the integrity of the election process. So what the heck does that mean? Well, what they're saying is, first of all, could you even prevent people from talking about the results? And secondly, if people were to leak this information, that very well could affect how people vote. If they think, oh, this guy's going to win, well, okay, I'll vote for him because I want to vote for the winner. Honestly, that does happen. And other things too. So what they're saying is there's a reason why election results are released after the polls have closed. Okay. The district court's order suppressing disclosure of election results showcases the unusual nature of the district court's order allowing absentee ballots to be mailed and postmarked after Election Day to be counted. And all of that further underscores the wisdom of the Purcell principle, which seeks to avoid this kind of judicially created confusion. So basically, any of these midnight decisions, last-minute decisions, cause confusion. And so we shouldn't do that, especially because it's judicially created, like the courts created this confusion. The dissent is quite wrong on several points, and we'll get to the dissent in a minute. First, the dissent entirely disregards the critical point that the plaintiffs themselves did not ask for this additional relief in their preliminary injunction motions. Second, the dissent contends that this court should not intervene at this late date. The dissent contends that this court should not. Oh, okay. The court would prefer not to do so, but I see. But when a lower court intervenes and alters the election rules so close to the election date, our precedents indicate that this court, as appropriate, should correct that error. Third, the dissent refers to voters who have not yet received their absentee ballots. But even in an ordinary election, voters who request an absentee ballot at the deadline for requesting ballots, which was this past Friday in this case, will usually receive their ballots on the day before or the day of the election, which in this case would be today or tomorrow. The plaintiffs put forward no probative evidence in the district court that these voters here would be in a substantially different position from late requesting voters in other Wisconsin elections with respect to the timing of their receipt of absentee ballots. In that regard, it bears mention that absentee voting has been underway for many weeks, and 1.2 million Wisconsin voters have requested and have been sent their absentee ballots, which is about 5 times the number of absentee ballots requested in the 2016 spring election. That's crazy. Let's just point that out for a second. The pandemic has been around for a minute now, right? Like, we've been out of school for almost a month, which is crazy. So in that time, Wisconsinites, or whatever they're called, would have been somewhat aware of, like, hey man, I don't want to go to the polls. Maybe I should put in for an absentee ballot. And keep in mind that the 2016 spring election was the primary for the last presidential election, the Hillary versus Trump one. That's important. Well, at that point, it would have been Bernie versus Hillary. But check this out. Most likely, even if this thing clears up by November, a lot of us will want to be not at the polls. This is my prediction. Okay. So you might think, well, why don't we just do mail-in ballots? Great question. But the thing is, it's very complicated. And this is an opinion piece by Politico. But this is talking about how, like, this is an issue. And it's like a whole thing, okay? But in addition to the legality of it, it's also a big logistical problem. So that's something that they're going to have to figure out before November, and they're not going to. It's going to be a mess. That's my prediction. But anyway, there's going to be a lot of people voting absentee this year. Okay, fourth, the dissent's rhetoric is entirely misplaced and completely overlooks the fact that the deadline for receiving ballots was already extended to accommodate Wisconsin voters from April 7 to April 13. Again, that extension has the effect of extending the date for a voter to mail the ballot from, in effect, Saturday 4, April 4 to Tuesday, April 7. That extension was designed to ensure that the voters of Wisconsin can cast their ballots and have their votes count. That is the relief that the plaintiffs actually requested in their preliminary injunction motions. The district court on its own ordered yet an additional extension, which would allow voters to mail their ballots after Election Day, which is extraordinary relief and would fundamentally alter the nature of the election by allowing voting for 6 additional days after the election. So let's just talk about that last part. So I think what they're saying is we are giving them the extension that they can vote, they can they can mail their ballot up until and including Election Day. It says normally that you'd have to turn it in early. You'd have to mail it early because it needs to be, I guess, counted or accounted for on Election Day. So I think what they're saying is we are giving you what they asked for. We are just saying no to the extra thing that the district court put on without even asking for it. The plaintiffs didn't ask for this. The district court gave it to them, and we are saying they can't do that additional extension. That's how I'm interpreting this. Therefore, subject to any further alterations that the state may make to state law, in order to be counted in this election, a voter's absentee ballot must be either 1, postmarked by Election Day, April 7, 2020, and received by April 13, 2020 at 4 p.m., or 2, hand-delivered as provided under state law by April 7, 2020 at 8 p.m. Okay. I feel like this paragraph is very important and is a good summary. The court's decision on the narrow question before the court should not be viewed as expressing an opinion on the broader question of whether to hold the election or whether other reforms or modifications in election procedures in light of COVID-19 are appropriate. That point cannot be stressed enough. I feel like that is what most of the news organizations are latching onto And that was my misinterpretation as well, right? I was thinking, well, why don't they just postpone it or something? That is not the question at hand. Just like in US v. Lopez, it wasn't about does he have a gun? Nope. Like he did. And I'm pretty sure he admitted that. But that's not the question. This question was not about should we postpone it? It did not say that. Okay. The stay is granted pending final disposition of the appeal by the U.S. Court of Appeals for the Seventh Circuit and the timely filing and disposition of a petition for a writ of certiorari, which we've talked about in class. Should the petition for a writ of certiorari be denied, this stay shall terminate automatically. In the event the petition for a writ of certiorari is granted, the stay shall terminate upon the sending down of judgment of this court. Okay, it is so ordered. Okay, good points. Good points. And this is the majority opinion. So again, most of the justices did agree on this. Now, there is a dissenting opinion written by RBG, Miss Ruth, or Justice, not Miss, Justice Ginsburg. And so this is the dissenting opinion. This is why they're saying we do not agree. And again, they're going to have good points too. That's what's so fascinating about these things is that it is not cut and dry. Very rarely, as I'll say again, very rarely do you have a Brown v. Board. Very rarely. Okay? So check this out. The district court, acting in view of the dramatically evolving COVID-19 pandemic, entered a preliminary injunction to safeguard the availability of absentee voting in Wisconsin's spring election. This court now intervenes at the 11th hour to prevent voters who have timely requested absentee ballots from casting their votes. I would not disturb the district court's disposition, which the Seventh Circuit has allowed to stand. So again, they're saying that this is at the last moment, the 11th hour, and they're trying to protect people from being disenfranchised, meaning prevented to vote. Okay, which will come up. Wisconsin's spring election is scheduled for tomorrow, Tuesday, April 7, 2020, which is today now. At issue are the presidential primaries, a seat on the Wisconsin Supreme Court, 3 seats on the Wisconsin Court of Appeals, over 100. Okay, you get it. In the weeks leading up to the election, the COVID-19 pandemic has become a quote-unquote public health crisis. As of April 2nd, Wisconsin had 1,550 confirmed cases of COVID-19 and 24 deaths attributable to the disease, quote, with evidence of increasing community spread, unquote. On March 24, the governor ordered Wisconsinites to stay at home until April 24 to slow the spread of the disease. Because gathering at the polling place now poses dire health risks, an unprecedented numbers of Wisconsin voters, at the current encouragement of public officials, have turned to absentee voting. Okay, about 1 million more voters have requested absentee ballots in this election than in 2016. Accommodating the surge of absentee ballot requests has heavily burdened election officials, resulting in a severe backlog of ballots requested but not promptly mailed to voters, meaning people, the citizens of Wisconsinites, are trying to obey the governor's order to stay at home and not go to the polls because today is election day. It's April 7, and the governor said to stay at home until April 24. So what she's saying is, and what they are all saying, is these citizens are trying to follow the recommendation of the governor. They are trying to keep themselves and their communities safe, and therefore they have, in a timely manner, have requested their absentee ballots. But I lost my shot. But the government of Wisconsin was not prepared for all of these extra people asking for the absentee ballots. And so, because of that, even though people have timely requested their ballot, they have not received it yet because the government was not expecting this surge. Okay. Several weeks ago, plaintiffs comprising individual Wisconsin voters, community organizations, and the state and the national Democratic parties filed 3 lawsuits against members of the Wisconsin Elections Commission in the United States District Court for the Western District of Wisconsin. The district court consolidated the suits on March 28th. The plaintiffs sought several forms of relief, all aimed at easing the effects of COVID-19 pandemic on the upcoming election. Something worth pointing out is how many times the dissent mentions COVID-19 pandemic and how little the majority opinion does. Another thing about this paragraph goes back to the idea of federalism and also voting. So voting, even for president and for Senate and stuff, are not done by the federal government. Voting is done by the state governments. So the only thing from what I can figure, the only thing that the federal government can do in relation to voting is to protect people from being disenfranchised, specifically like literacy tests, poll taxes, those kinds of things that were going, especially against African Americans and poor people back in the day. More recently with, Purcell, we're talking about voter ID. Voter ID is very, very controversial and popular topic to talk about. And so here they're talking about basically, again, the disenfranchisement of people, the potential at least. So that's worth noting, is that states are in control of their voting and their elections. However, if they are discriminating or disenfranchising people, then the federal government can get involved. Okay. After holding an evidentiary hearing, the district court issued a preliminary injunction on April 2nd. As relevant here, the court concluded that the existing deadlines for absentee voting would unconstitutionally burden Wisconsin citizens' right to vote. Again, disenfranchisement. To alleviate that burden, the court entered a twofold remedy. First, the district court extended the deadline for voters to request absentee ballots from April 2nd to April 3rd. Second, let's see, when did the governor? Okay. Second, the district court extended the deadline for election officials to receive completed absentee ballots. Previously, the Wisconsin law required the absentee ballots be received by 8 p.m. on Election Day, April 7th. Under the preliminary injunction, the ballots would be accepted until 4 p.m. on April 13, regardless of the postmark date. The district court also enjoined members of the Election Commission and election inspectors from releasing any report of polling results from before the new absentee voting deadline, April 13. Going back to the majority opinion, they were saying that they think that that information will be leaked anyway. So how can you guarantee that? Although the members of the Wisconsin Elections Commission did not challenge the preliminary injunction, the intervening defendants applied to the Seventh Circuit for a partial stay. Of the twofold remedy just described, the stay applicants challenged only the second aspect, the extension of the deadline for returning absentee ballots. On April 3rd, the Seventh Court declined to modify the absentee ballot deadline. The same applicants then sought a partial stay in this court, which the court today grants. Okay. The court's order requires absentee voters to postmark their ballots by Election Day, April 7, i.e. tomorrow, even if they did not receive their ballots by that date. That is a novel requirement. Recall that absentee ballots were originally due back to election officials on April 7, which the district court extended to April 13. Neither of those deadlines carried a postmark by requirement. While I do not doubt the good faith of my colleagues, the court's order, I fear, will result in massive disenfranchisement. That's interesting. Again, the Supreme Court is a very good example of how to disagree with people in a totally civilized, logical way. So she's saying, like, I respect my colleagues, and I know that what they're doing is with the proper intention. However, I feel like there is a potential, almost a guarantee, for a negative repercussion, which is massive disenfranchisement. A voter cannot deliver for postmarking a ballot she has not received, right? Yet tens of thousands of voters who timely requested ballots are unlikely to receive them by April 7, the court's postmark deadline. Rising concern about the COVID-19 pandemic has caused a late surge in absentee ballot requests. Okay. So what she's saying is they're following the rules. They requested the ballot in a timely manner, but they don't have it yet. And so they did the right thing. So by not allowing them to cast their ballot because they have not received it yet because of the government, that's not on the citizen, and therefore you are taking away their right to vote for something that's beyond their control. The court's suggestion that the current situation is not substantially different from an ordinary election boggles the mind. Some 150,000 requests for absentee ballots have been processed since Thursday, state records indicate. The surge in absentee ballot requests have overwhelmed election officials who face a huge backlog in sending ballots. As of Sunday morning, 12,000 ballots reportedly had not been mailed out. As of Sunday morning, 12,000 ballots had not been mailed out. That is not the fault of the person, of the citizen, right? If they put it in advance, which they did, that's not their fault. It takes days for a mail ballot to reach its recipient. The Postal Service recommends budgeting a week, even without accounting for pandemic-induced mail delays. So if they have not been sent out by Sunday, they're not going to get it until most likely next Sunday, right? It is therefore likely that ballots mailed in recent days will not reach voters by tomorrow. For ballots not yet mailed, late arrival is all but certain. Under the district court's order, an absentee voter who receives a ballot after tomorrow could still have voted, as long as she delivered it to election officials by April 13. Now, under this court's order, tens of thousands of absentee voters unlikely to receive their ballots in time to cast them will be left quite literally without a vote. That's disenfranchisement. This court's intervention is thus ill-advised, especially so late at this hour. And then she mentions Purcell, which is this one, right? And that's interesting. Election officials have spent the past few days establishing procedures and informing voters in accordance with the district court's deadline. For this court to upend this process a day before the April 7 postmark deadline is sure to confound election officials and voters, meaning like confuse them. What concerns could justify consequences so grave? The court's order first suggests a problem of forfeiture, noting that the plaintiff's written preliminary injunction motions did not ask that the ballots postmarked after April 7 be counted. But, unheeded by the court, although initially silent, the plaintiff specifically requested that the remedy at the preliminary injunction hearing in view of the ever-increasing demand for absentee ballots. Second, the court's order cites Purcell, apparently skeptical of the district court's intervention shortly before an election. Never mind that the district court was reacting to a grave, rapidly developing public health crisis. If proximity to the election counseled hesitation when the district court acted several days ago, this court's intervention to today, even closer to the election, is all the more inappropriate. Third, the court notes that the district court's order allowed absentee voters to cast ballots after Election Day. If a voter already in line by the poll's closing time can still vote, oh, that's a good one. Why should Wisconsin's absentee voters already in line to receive their ballots be denied franchise? I think that's the best argument. I'm going to read that again. If a voter already in line by the polls closing time can still vote, meaning like, let's say polls close at 7, you are in line and you still have not been able to vote yet, and it's 7:05, but you're still in line, you could still vote. Why should Wisconsin's absentee voters already in line to receive ballots be denied the franchise, the right to vote? According to the stay applicants, election distorting gamesmanship oh, might occur if ballots could be cast after initial results are published. But obviating that harm, the district court enjoined the publication of election results before April 13, the deadline for returning absentee ballots, and the Wisconsin Elections Commission directed election officials not to publish results before that date. The concerns advanced by the court and applicants pale in comparison to the risk that tens of thousands of voters will be disenfranchised. Ensuring an opportunity for the people of Wisconsin to exercise their votes should be our paramount concern. Let me say that again. Ensuring an opportunity for the people of Wisconsin to exercise their votes should be our paramount concern. The majority of this court declares that this case presents a narrow technical question. That is wrong. The question here is whether tens of thousands of Wisconsin citizens can vote safely in the midst of a pandemic. Under the district court's order, they would be able to do so. Even if they receive their absentee ballots in the days immediately following Election Day, they could still return it. With the majority stay in place, that will not be possible. Either they will have to brave the polls, endangering their own and other safety, or they will lose their right to vote through no fault of their own. That is a matter of utmost importance to the constitutional rights of Wisconsin citizens, the integrity of the state's election process, and in this most extraordinary time, the health of the nation. So, this is fascinating. Again, both sides have good points, and most likely you will fall on one side and not the other. But nonetheless, it's fascinating. And this is totally unprecedented times. I mean, that's not totally true. Like, we were due for a plague, let's be honest. But this just makes it more complicated. And again, it begs the question, well, what are we going to do in November? Like, Dr. Fauci the other day said, and they've been saying this for a long time, like, life will not go back to normal until we have a vaccine. And vaccines take a while to make, right? So if we're just talking about 7 months from now, the November election, that it won't be ready by that time. So there's a lot of question marks at this point in time. And who knows what the future is going to hold. But I hope this was interesting. Probably not. You probably turned it off already. But yeah, I'm interested to hear your opinions, and stay safe.